War over abortion. There is a dispute between state governments and the federal government over who should have control over abortion laws. In the 1960s, there was a case called Griswold versus Connecticut. The state of Connecticut had a law that prohibited birth control. The case was brought to the Supreme Court, where ultimately Connecticut's law was deemed unconstitutional because it violated the right to privacy between couples. In the Roe v. Wade case, abortion was essentially legalized, as it was protected by the 14th Amendment. In a third case, Planned Parenthood v. Casey, it was decided that minors needed parental consent, a 24-hour waiting period, and that a woman does not have to notify her husband of her abortion. Each state has a different waiting period, which contributes to their ability to make their own laws based on their state's beliefs. A waiting period is when a woman goes to the doctor to schedule an abortion, and the doctor gives them a time period that they have to wait until they receive it. The purpose of waiting periods is that it allows for education of the process of abortion and emotional support. The waiting periods throughout the states range. For example, in Alaska, there is no waiting periods. In Indiana, it is an 18-hour wait, and in South Dakota, it is a 72-hour waiting period. As you can see, they are quite different. From state to state. Parental consent is when people under a certain age are required to get permission from a parent or guardian. In Alabama, one parent's permission is required, but it can be excused by a judge. In California, no permission is required. In Utah, one parent's permission is required, and separately, one parent must be told of your decision 72 hours before the abortion takes place. A judge can excuse you from the first requirement, permission, but not the second, that a parent be told. You can be excused from the second requirement if you have only one parent and that parent has abused you, and your doctor reports that abuse to the appropriate authorities. You can also be excused from this requirement if your parent has failed to take responsibility for your care. In Wisconsin, permission is required from one of the following: a parent, a grandparent, an aunt, uncle, or sibling who is at least 25 years old. A judge can excuse you from this requirement. There are pros and cons of having it either a state or federal power. The pros of having it as a state power is that it allows individual states to have what they believe is the best for that state. If a citizen disagrees with the laws of that state, they are not forced to stay. It allows for diversity between the states. Cons are that it could force citizens who disagree or don't like the laws to uproot themselves. Also, it could allow states to make laws basically prohibiting abortion, and it may be argued as unconstitutional. Pros for having it as a federal power are that it would be the same decision or law everywhere, and people would not have to leave their state. Cons would be that the federal government could actually limit the amount of states that allow abortion, and also people get less of a say when voting at a federal level. Ultimately, the 10th Amendment states that if it is not a power listed in the Constitution, and making laws regarding abortion is not, then it is the power of the states to make laws regarding it.